Before we go back to autoerotic asphyxia. Brandenburg makes the distinction between advocacy, protected, and incitement not. And the ability to advocate hateful, terrible ideas distinguishes us from other countries where, for example, Holocaust denial is a crime. And speech advocating racial hatred, religious hatred, is not allowed. Whereas here, for better or for worse, it is. And it's becoming a little more controversial, I guess. This bake sale business on campus stirred up a lot of people, thought that it was hateful, wrong-headed, and so on. Does anybody, maybe you know these people, I don't know, does anybody think that they didn't have a First Amendment right to put on that bake sale? Racially based as it was on campus? I don't either. I mean, clearly, you may think it was wrong-headed, hateful, inappropriate, but you can't say that they did not have a First Amendment right to do that, even though it was bad satire. Maybe the cartoon of Jerry Falwell was bad satire too. The Brandenburg Standard seems to have replaced the clear and present danger test for determination of when subversive speech may be suppressed. The court no longer uses the clear and present danger test after Brandenburg. Sometimes it slips in here and there, but by and large the question is whether the speech would incite imminent unlawful force, violence, violation of law, and if it doesn't, it cannot be suppressed. Not everyone agrees with that these days. Anthony Lewis, the famous New York Times correspondent, covered the Supreme Court for many, many years and has written books on the First Amendment, for example, thinks that the Brandenburg Standard is insufficiently protective of our safety in an era in which terrorist speech and extremist speech actually result in killing people. And Lewis in particular is concerned that the imminence requirement of the Brandenburg Standard allows speech which is inflammatory and likely to incite members of the audience, for example, of jihadist clerics who say, go out and kill Americans. There are enough people in that audience, according to Lewis, who might actually do that we shouldn't insist that the danger be imminent as long as it's real and is in fact incited by the speech. One of the clerics that comes to mind is al-Awlaki, who was assassinated, of course, not long ago by a drone in Yemen. But he's an American-born cleric who went to Yemen and has influenced a large number of radical Islamists to undertake terrorist actions against the United States. So the question is not do we have a right to kill somebody. That's a separate question that the Attorney General of the United States addressed a few days ago in a lecture at Northwestern University Law School. Not whether he should be killed by our government, but whether he could be silenced by legal means consistent with the First Amendment. And I'm not convinced that we can shut down extremist terrorist speech that does not meet the Brandenburg Standard, or that we should even try. I think you can try it if you wish. Draft another standard that would apply to somebody like al-Awlaki, but wouldn't suppress dissident, unsettling speech that ought to be protected by the First Amendment. It's terribly difficult to draw that line. Robert, you have one?
No, I was going to say that would be really difficult to deal, especially with something like that,
because of its religious affiliation? I don't think that matters. I mean, that somebody happens to be a religious cleric doesn't immunize them from the criminal law and the rules that affect us all, wherever we are, whoever we are. Tina?
How exactly do you define imminence? Because if someone kills somebody and you know that they were incited by terrorist speech, how soon after this do you need it to follow?
There's no rule on how many minutes, hours, days, or weeks the event must occur in. It's just a judgment call. And it reminds me of the argument in the Pentagon Papers case where it wasn't imminence wasn't the key word, but immediate was the key word. I don't think it's any different here. The question is one of causality. Will the speech cause the horrible result? For sure. And if it will for sure, it's probably imminent enough. But it's hard to know, and it's very predictive. I mean, we're talking about speech here that if the preacher gets up and says those abortion doctors are murderers and deserve what they give those unborn children, a quick death, and 2 weeks later one of the parishioners goes out and kills an abortion doctor, should the preacher be legally responsible for causing that death? Well, if so, then the crime is committed at the time of the speech, whether anybody is killed or not. And we'll never know if you come around and arrest him. And it ought to matter whether there is time for more speech or action by law enforcement if the crime can be headed off so that the speech need not be suppressed. I don't pretend that there are any easy answers to any of this, but I think the general principles are ones that go to the heart of what it means to be an American today. Yes, Robert?
But I think that in a situation like that, some sort of state of being, whether or not a reasonable person would, understand, that person's sermon or whatever talking about abortion doctors as, as a reasonable incitement action, do harm to somebody. Like in a situation with the website and the crosshairs over certain districts on the map, and the kid going into that different, he was obviously missing a deal from all the content I get. So is that website responsible reasonable for citing that. I think the question becomes whether or not the person would make that judgment.
Yeah, importing the reasonable person into the test is a common technique under our legal system, where it supposedly introduces some objectivity into what would otherwise be a subjective determination. You don't say, how do I feel about this? Would I be incited by this? You pull back and construct a hypothetical reasonable person who would do that. And that's a technique that's used in many statutes too. It has not been used in the advocacy incitement context, and it may be worth exploring, but you'd have to say more than that a reasonable person would be incited to imminent lawless action. What about an unreasonable person? What if there are a lot of unreasonable people in the audience, and they would be incited by the speech, and the speech in fact incites them? Is the preacher off the hook? Does it matter if the preacher wants that result? Does it matter if the preacher knows that there are unstable people there? Lots of questions here. Go back to first principles, though, and one of the great First Amendment scholars, Alexander Michaeljohn, during the McCarthy era, in the early 50s, had the courage to go before a Senate committee and testify about the need to allow communists in particular, because that was the focus of the day, but people generally, all of us, to be able to advocate ideas that the great majority of people thought were dangerous. And he concluded his testimony by saying, no belief or advocacy may be denied freedom if in the same situation opposing beliefs or advocacies are granted that freedom. If then on any occasion in the United States it's allowable to say that the Constitution is a good document, it's equally allowable to say that the Constitution is a bad document. To be afraid of any idea is to be unfit for self-government. So let's go back to autoerotic asphyxiation, from the sublime to the ridiculous, and look at the dissenting opinion of Judge Edith Jones, who says that nobody has ever suggested that death is a legitimate price to pay for freedom of speech. How did you like her analysis? I mean, that gets your attention, right? That death is too high a price to pay for freedom of speech. What she was disturbed about was foreclosing the possibility that a state might choose to temper the excesses of the pornography industry by imposing liability for the harms that it directly causes. And she says that allowing this kind of suicidal pornography, as Hustler put in the magazine, is to degrade the free market of ideas to a level with the black market for heroin. And her analysis is interesting, that her assertion is that Hustler is not a legitimate player in the marketplace of ideas, not a bona fide competitor in the marketplace of ideas. Why? Because it's largely pornographic. The principal function of this magazine is to create sexual arousal. Like Larry Flint said one time, most men read this magazine with one hand. The definition of pornography's appeal, according to Judge Jones, is non-cognitive, unrelated to the transmission of ideas, and therefore undeserving of First Amendment protection. And then she looks at whether the pornography industry should be insulated from liability for causing harm, and especially to teenagers like Troy D., who read the article and died as a result. Hustler knows that a significant portion of its readers are adolescent, and it certainly should know that these readers are particularly vulnerable to thrill-seeking, recklessness, and mimicry, so that warnings, there were 10 of them on this article, warnings, don't do this, or caution, are treated by those readers as invitations. Let's try it. And she concludes that pornographers like Flint and Hustler don't deserve any First Amendment protection for the harms that they actually cause. Majority, of course, rule that the First Amendment protects Hustler even when it causes death through the publication of an article like this. Just so that you didn't get misled by Judge Jones, who, by the way, almost was on the Supreme Court. She was the first George Bush's first choice for a Supreme Court opening. And at the last minute, one of his advisors, Sununu from New Hampshire, was persuaded that David Souter would be a better and safer and more reliable justice for the Bush administration. And so Souter was selected over Jones. Souter, of course, turned leftward once he got on the court and didn't satisfy the Bush administration's expectations. By the time he retired a couple of years ago, he was viewed as a liberal on the court. Edith Jones has remained a rock-ribbed conservative on the Fifth Circuit Court of Appeals. She was a former bankruptcy lawyer in Houston, a deeply conservative person, but she makes some interesting and provocative points in the dissent that I thought you ought to pay some attention to. The last thing she says, though, is not right. She says her analysis differentiates this case from Brandenburg versus Ohio, which addressed prior restraints on public advocacy of controversial political ideas. No prior restraint in Brandenburg. It had nothing to do with prior restraints at all. Right? It was simply, the law in Brandenburg was a garden variety criminal law in which punishment of the speaker occurred after the fact, as subsequent punishment, not as a prior restraint. Nobody tried to prevent Brandenburg from speaking in advance. So, questions about Brandenburg or the Hustler saga? No? Okay, let's turn to the American Booksellers case, which is really very interesting. This opens up the question of sexual speech, which we'll come back to time and again because there have been so many attempts to restrict expressions about sexuality. What's up, Kelly?
Why does it matter that Jones says prior restraint, even though that was wrong? Like, why do you?
Well, I didn't want you to be misled by her saying that Brandenburg had something to do with prior restraints, that's all. You can't take what a judge says as gospel in every situation. Sometimes they get it wrong, she got it wrong there.
Even if you got it wrong, it wasn't like a huge.
No, not a huge deal, no, and a law clerk would have tugged her at the sleeve and say, wait a minute, Brandenburg didn't have anything to do with prior restraints.
With the pretty much just seems to be the government that cleans it out. With the incitement standard, has it ever been used to actually convict someone of kind of causing incitement? I believe that that standard was to stop the fact that the government benefit of the doubt as speech.
I don't remember a case in which it has been, the Brandenburg standard has been satisfied by the government to the point that somebody's conviction has stood up. There may well be some. There was a case a few years ago involving the abortion situation where somebody's website published the names and addresses and contact information for abortion doctors up in Oregon. And the website included a lot of inflammatory rhetoric about that abortion is murder and so on. And that was viewed as a threat, as a true threat, which the courts say that the government can prevent a true threat of physical harm. Not an idle threat, but maybe one that a reasonable person would perceive to be a true threat. I don't think the Brandenburg analysis was used there, but I'm not sure. Okay, pornography again. And the attempt was made not too long ago by an academic by the name of Catherine McKinnon, who teaches at the University of Michigan Law School, and her colleague, Andrea Dworkin, to get pornography treated as sex discrimination, as a form of sex discrimination. And they managed to get the city of Indianapolis to pass the ordinance that was considered in the American booksellers case. And the question that they raise is whether publications like Hustler, and probably more relevant, are videos, dirty videos, sexually explicit videos. But for example, look at one of the covers of Hustler magazine. This was at a point when Larry Flynt decided that he would stop treating women as subservient sex objects who would be hung up like pieces of meat. This ordinance, as you see, defines pornography, which is not a legal term in any other context, as a form of sex discrimination. And under the Indianapolis ordinance, pornography was defined as the graphic sexually explicit subordination of women, whether in pictures or in words. That also includes one of 6 other factors, one of which is women are presented as sexual objects who enjoy pain or humiliation, or sexual objects who are tied up or cut up or mutilated. And number 6 says women are presented as sexual objects for domination and so on, or through postures or positions of servility or submission or display. Is this one? Does this fall within that definition of pornography? Does display of a couple, male and female, in the missionary position, this is through postures or positions of servility, is a depiction of the missionary position, a violation of this law? Could be. The rationale of the law was that pornography affects behavior. But the law does not use the concept of obscenity. We're talking about sexually explicit material that is not obscenity. The meat grinder picture would not satisfy the requirements that ought to be real familiar to you now about what it takes to be obscene, and appeal to the prurient interest, the interest in sexual arousal. Secondly, that the depictions of the sexual acts must be, quote, patently offensive, as judged by contemporary community standards. And finally, that the material must lack serious literary, artistic, political, or scientific value. Well, the Indianapolis ordinance did not deal with obscenity, which means that did not require any of these 3 elements to be present: prurient interest, patently offensive, or, and what struck the court considering the ordinance, material that in fact has serious literary, artistic, and so on value may well violate this this ordinance. As I say, this obscenity then keeps intruding on our discussion of the First Amendment. Professor Kathleen Sullivan, who used to be dean of the Stanford Law School, was highly critical of the definition of obscenity. She said, look at the first one, the appeal to the prurient interest. That's material that, in colloquial usage, means it turns you on. And then the second one, it's patently offensive, as judged by community standards. That is, it grosses you out. It's incoherent, she says. Simultaneously, the material must turn you on and gross you out. And the definition is subjective enough, the terms are loose enough, that the definition of obscenity itself is risky to free speech. But at least these days, the government very rarely prosecutes an obscenity case, and to the point of never prosecuting books with words in them and stuff like that, or magazines like Hustler. Rather, what seems to be the only interest by the government is really raw videos, usually involving violence, rape, and ugly bestiality, very bizarre stuff, not just vigorous sexual activity. But the Indianapolis ordinance involved in the American booksellers case